Okay, ladies and gentlemen, now is 11 p.m. So we start to the next panel of our conference. So now I give the floor to the Professor Erika Roth from University from Miskolc, and with the paper, The Right to be Present at the Trial in the Criminal Proceedings. Welcome, Mr. Professor. Mr. Professor.
Thank you. As you know, my name is Erika Roth, and I am Professor of Criminal Procedure at the University of Miskolc Faculty of Law. And now I will speak about the right of the accused, a very important right of the accused to be present at the trial. But first of all, I would like to say thank you for organizers, and it is a great pleasure for me to meet you, at least in the online world. So, the presence of the accused at criminal trials and trial the case in absentia have a long history, but rules change relatively frequently. What makes the topic absolutely current is the fact that the European Commission published its report on the implementation of Directive 343 of 2016 to the European Parliament and the Council on 31st of March this year. The right of accused person to be present at the trial is based on the right to a fair trial, and that right should be ensured throughout the Union. I will examine this right from the accused aspect in the main part of my lecture, but at the beginning, let me make a short detour. When we speak about the presence at own trial in criminal cases, in a broader context, two participants could be concerned, the accused and the victim. Although it is obvious that that fundamental right is examined from the accused point of view, let me say a few sentences about the victim before analyzing the accused right to be present at the court trial. The victim was a regrettably neglected actor of the criminal proceeding for a long time, who were important only if he could have the administration of justice by testifying as a witness. I would like to mention that in order to be more simply, I will use only he and not he or she in my lecture. It was a very important action in the EU legislation when the Council Framework Decision of 15th March 2001 was adopted. Although the primary aim of the Framework Decision was to afford victims of crime a high level of protection, and therefore it contains several measures to assist victims before or after criminal proceedings, the effect of this regulation was the improvement of victims' position. In the Directive 29 of 2012, we can find more concrete requirements regarding procedural rights of victims, among others, rights to be informed, which is obviously necessary for him to decide about his participation if it is not compulsory at the given trial. And now I return to the original topic, the accused presence at trial. First of all, it is very important to emphasize that in modern law systems, to be present at criminal trial is not primarily a duty, but mostly the right of the accused person. What is more, the accused right to be present at trial is a key component of right to a fair trial. Although the European Convention of Human Rights doesn't define directly the right to be present at the trial, the accused may not exercise certain specific rights if he is not present at the trial. But if the accused person is present at this trial, he can exercise his other rights to defend himself in person, to testify, to tell his version about the alleged offense, to put questions to witnesses and to other accused, to make comments, to submit motion for evidence, and so on. But not only to be present is the right of the accused, but as the other side of this right, he is entitled to waive to be present. Under certain conditions, accused persons should be able, expressly or tacitly, but unequivocally, to waive that right. The right of accused person to be present at the trial is not absolute, but it might be limited only when the interest of justice requires the opposite solution. At one hand, it means that the accused might be obliged to be present at trial, and at the other hand, his case can be tried in absentia. Rules on these limitations must be clearly defined by law and must meet the constitutional requirements. If we examine the title of Directive 343 of 2016, one question might be emerged. What is the connection between presumption of innocence and the right to be present at trial, if any? We can find the official answer in the Commission's staff working document. In impact assessment, it is written that the right to be present at trial is also closely connected with presumption of innocence. One of the key requirements of presumption of innocence is, as set out by the European Court of Human Rights, the right of the suspect or accused to be informed of the case against him, consequently the right to be present at trial, or being able to waive such right after having been informed of it, is indispensable for the exercise of the right to be informed of the case. If a suspect or accused is not given the opportunity to be present at trial because he was not informed of it, it is his right to be informed on the case that is also at stake, and thus his presumption of innocence. The right to be present at the trial is linked to the right to be informed of the accusation, so that the accused may prepare and present his defense accordingly. Consequently, if a person is not present during the hearing, it is his right to defend himself that it is at stake. The defendant will, in that case, neither be able to give his version of the facts to the court, nor will be able to present evidence accordingly, and might therefore be found guilty without enough grounds for such a conviction. As you all know, the right to be informed was the subject of the other EU directive adopted in 2012. The next question is whether to try a case in absentia is compatible with the EU legislation and the European Convention on Human Rights or not. There are at least three versions, in my opinion, when trial in absentia doesn't violate the fair trial rights. One is when the accused who was summoned and doesn't appear before the court. The second is when the accused definitely waives his rights, his right to be present at the court trial, and the court has no reason to oblige him to appear before the court. The third case is when the law itself provides a possibility to conduct a trial in absentia of the accused. For example, if the accused place of stay unknown or he stay abroad, but the extradition is not a possible solution. The difference between these cases is that in the first two cases, the retrial of the case isn't necessary, is not compulsory, but in the third case it is, if the accused requires so. According to the directive, it is very important guarantee that the accused should have the possibility to request a new date for trial if he was unable to be present at the trial for reasons beyond their control. After that general analysis, I would like to provide a short introduction into Hungarian regulation concerning the topic. Hungarian Code on Criminal Procedure decides when the presence of the accused is mandatory at the trial before the first instance court. A contrario, it means that in other cases, the accused has right to decide whether he wants to be present or not. The accused may waive his right to be present at the trial at any time after the indictment has taken place if he has a defense lawyer and this defense lawyer is entrusted with the duties of service agent. The presence of the accused at the trial is mandatory if he didn't waive the right to be present at the hearing, and or if the court ordered that he should be present at the hearing. The next question that arises is when the court can oblige the accused to be present at trial. The court may order an accused who has waived his right to be present at the trial if it is necessary for taking evidence or the so-called service agent is unable to fulfill his duty. Even if the accused didn't waive the right to be present at the trial, at least a part of the trial may be held in the absence of the accused in some cases. Just mention these cases.
Dear Professor?
Sorry?
Please go to conclusion because of lack of time.
Okay, so I do not speak about these cases, but I would like to mention that there are special procedures in Hungarian Code on Criminal Procedure which are connected with the absence of the accused. And I would like to mention that Hungarian Constitutional Court played a definitive role in elaboration of preconditions of the procedure against an absent accused by its decision 14 of 2004, declaring that the former rules were unconstitutional and defining criteria when in absentia trial may be acceptable. There are some cases when presence of the accused is necessary for proper conduction of the trial, and as opposite, the restriction of that right might be necessary for proper conduction of the trial and for maintenance of the order. As concern my conclusion, I would like to emphasize that in my short presentation, I try to speak about the importance of presence of the accused at the trial held before the first instance court, and examining the directive, the report of the Commission and its implementation and our national law, I can say that implementation of requirements was appropriate. Although there may be problems in the judicial practice, but in my opinion, these are not originated in failure of the legislation. Thank you for your kind attention.
Thank you, dear Professor, for your interesting speech. And now I give the floor to Dr. Andrea Janozzi with the paper Some Practical Questions related to taking account of convictions of EU member states in the course of new criminal proceedings in Hungary. Please welcome.
Thank you very much. Can you hear me?
Yes, very well.
Okay, thank you. It's my great pleasure to be here. So thank you very much for the opportunity, and thank you very much for the organizers. As you mentioned earlier, my short topic today is some practical questions related to taking account of convictions of EU member states in the course of new criminal proceedings in Hungary. In order to give a brief overview about this topic, in my opinion, we should take into account two relevant EU sources. The first one is the Council Framework Decision on taking account of convictions in the member states of the European Union in the course of new criminal proceedings. And the second one is the Framework Decision on the organization and content on the exchange of information extracted from the criminal record between the member states. First of all, let's see some relevant information about these EU sources. The purpose of the first framework decision is to establish a minimum obligation for member states to take into account convictions handed down in other member states. It establishes the criteria whereby previous convictions handed down in one EU country are taken into account during criminal proceedings in other EU country against the same person, but for different facts. In the context of new criminal proceedings, EU countries must ensure that previous convictions are taken into consideration under the same condition as domestic previous convictions. According to the principle of equivalence, it means that the effects of a conviction should be equivalent to the effects of a national decision at the trial stage of criminal proceedings, at the trial stage, and at the time of execution of the sentence. According to this framework decision, conviction means any final decision of a criminal court establishing guilt of a criminal offense. Moreover, it should noted that this framework decision replaced the related provisions of the European Convention on the international validity of criminal judgments. Where previous convictions are taken into consideration by the EU country conducting the new proceedings, this must not have the effect of interfering with, revoking, or reviewing the previous convictions. In 2014, the Commission published a report on the implementation of this framework decision. And at the time of the report was published, the Commission has received notification on the national transposition laws from 22 member states. Hungary was among these countries. In general, the member states have chosen a mostly similar approach for transposing the framework decision into their national legislation and criminal law. In Hungary, similar to the most member states, competent authorities have to apply a dual criminality requirement when taking into account previous convictions. And if this conviction was based on crime that is also recognized and punishable under the law of the member state. At that time, the wording of Hungarian law was slightly differed in this respect. It contained the sentences imposed or measures stemming from a decision of a foreign court cannot be contrary to Hungarian law. Some member states have set more conditions which have to be fulfilled in addition to dual criminality requirement. An example is the obligation that in addition to dual criminality, sufficient information must be available about the previous conviction. According to the Hungarian legislation, which was in force at that time, Hungary submitted foreign convictions to an extensive recognition procedure before they could be taken into account. Let's see the earlier mentioned second framework decision. This framework decision is closely related to the Council decision on the establishment of the European Criminal Record Information System. The purpose of this framework decision is to improving the circulation of information on convictions. It defines the ways in which a member states where a conviction is handed down against a national of another member state transmits the information on such a conviction to the member states of the convicted person's nationality. And it also defines storage obligations for the member states of the person's nationality and specifies the methods to be followed when replying to a request for information extracted from criminal records. The information can be exchanged for the purpose of criminal proceedings or for any other legitimate purpose, for example, for pre-employment screenings. Moreover, the framework decision also laid down the framework for a computerized system of exchange of information on convictions between member states. Finally, ECRIS became operational in April in 2012. This system is based on a decentralized architecture where criminal records information is exchanged electronically, exclusively between the central authorities of the member states. In 2016 and 2020, the European Commission published reports on the exchange through ECRIS of information extracted from criminal records between EU countries. Let's see some words about the main findings of the latest report. The latest report highlighted that in 2019, all member states were active in using ECRIS, but 9.8% of the possible interconnection were still missing. However, one of the EU countries, Spain, is exchanging information with the other member states. The number of messages exchanged reached 4.2 million in this year. The number of requests for information has tripled since 2017. The high increase is due mostly to the shift in the use of ECRIS, not used anymore exclusively or even mainly for the purpose of criminal proceedings, but also for purposes other than criminal proceedings, for example, the earlier mentioned pre-employment screening, or for example, request on one's own criminal record. There were significant differences between the member states' ECRIS activities and workload. Some member states, for example, send considerably more requests for information than receive, while other member states are confronted with a significant workload replying to the request, for example, Poland, Romania, Italy, or Hungary as well. This framework and the framework decision was amended in 2019. A new regulation and a new directive were adopted. This new framework aims to ensure the effective exchange of information on convictions of non-EU country nationals through ECRIS. Under the new regulation, a new centralized system, ECRIS TCN at European level will be created, containing the personal data of convicted third country nationals, allowing identification of the member states holding information under previous convictions. And what are the main features, main characters of the Hungarian legislation or proceedings? In Hungary, the Act number 180 of 2012 on judicial cooperation in criminal matters with the member states of the European Union contains the rules and procedure how to recognize the validity of a conviction handed down in other member states. The related rules were restructured from the 1st of January in 2018 18. The previous legislation did not differentiate between the procedure for recognizing the validity of a judgment of a member state and of a third country. Act number 38 of 1996 on international mutual assistance in criminal matters comprehensively included the rules for recognition of the validity of a foreign judgment. This act necessitated a special procedure for recognition. The structure has already changed from 2018, as I mentioned earlier. And finally, I would like to mention two preliminary rulings before the Court of Justice of the European Union. This is the last few words which are missing from my presentation. Two preliminary rulings should be mentioned. The first case is number 2025 in 2015. The dispute was the following: by the judgment of 2014, the Regional Court of Eisenstadt in Austria sentenced the Hungarian national to a term of imprisonment. The content Austrian authority informed the International Criminal Law Department of the Hungarian Ministry of Justice about the content of the judgment. The department transmitted the judgment to the Budapest Regional Court as the court with jurisdiction for the recognition of the validity of the judgment in Hungary, and the special procedure which involves neither a new assessment of the fact or of the criminal liability of the convicted person, nor a fresh conviction, has as its sole purpose to accord to the judgment of the foreign court the same status it would have had if it had been delivered by the Hungarian court, and is essential for that person. Finally, according to the judgment of the European Court of Justice, the EU rules must be interpreted as precluding the implementation of national legislation establishing such a special procedure that I mentioned before. The case was similar in case 319/2016. The conclusion was the European Court of Justice was quite similar. Thank you for your kind attention.
Thank you very much for this interesting presentation. And now I give the floor to the Dr. Bence Umberheli from University of Miskolc with interesting paper, Actual Question and Problems Relating to the European Public Prosecutor Office. Please welcome, Doctor. Our Dr. Bence is with us.
Yes, I am here.
Please welcome.
I had some technical problems about my internet connection, but I hope it won't hinder my presentation. Just a short question. Can I share my presentation?
Yes, you can share it.
Okay, just a moment.
And
now can you see?
Yes.
Okay, thank you very much. Okay, thank you very much. My name is Bence Umberheli. I am also from the University of Miskolc, an assistant professor at the Institute of Criminal Science, Department of Criminal Law and Criminology. First of all, I also would like to thank for the organizers the possibility to be part of this very interesting conference. According to my lecture, I would like to highlight some actual questions and problems relating to the European Public Prosecutor's Office. First of all, I would like to answer the question why the EU needs to protect its financial interest. This question can be answered with financial reasons and political reasons as well. Of course, the criminal offenses against the financial interests of the European Union causes significant losses to the EU. According to some estimations, the overall damage caused by these criminal offenses can reach 10 or even 20% of the EU budgets. Apart from this, there are some political reasons as well in connection with this problem. For example, these criminal offenses causes illicit competition against the economic operators in the member states because the perpetrators of these criminal offenses often choose for the commitment of the offenses the member state where the penalty the most lenient is. Furthermore, in the long term, crimes against the financial interests of the European Union can also affect the credibility, confidence, and political acceptance of the European Union. Therefore, in the long terms, it may seriously slow down the process of the European integration. The European Union also realize these risks and try to create a coherent and effective framework to combat criminal offenses against its financial interests. The Treaty of Lisbon was an important milestone in the history of the protection of the financial interests of the EU, since it empowered the Union with a broad legislative competence, based on which two very important legal acts were adopted, the so-called PIF Directive and the EPPO regulation. The PIF Directive contains the substantive criminal law regulation, while the EPPO regulation contains the criminal procedural rules of the financial interests of the European Union. In this presentation, I would like to focus only to the EPPO, and it can be said that the analysis of the European Public Prosecutor's Office is extremely current nowadays, since the EPPO has begun its activity in the 1st June 2021. However, it's worth highlighting that the EPPO is not competent in each member state, since it was established within the framework of an enhanced cooperation, which means that some member states, including, for example, Hungary and Poland, don't participate in the work of the EPPO. In my presentation, I don't want to cite pro and con arguments of the accession of to the EPPO. Instead of this, I would like to emphasize some problematic points of the EPPO regulation, based on which I would like to answer the question whether the European Public Prosecutor's Office could provide for a better and for a more unified protection to the financial interests of the European Union. In my presentation, I would like to focus on three different topics. First of all, I would like to speak some words about the material competence of the EPPO. The material competence of the EPPO can be divided into three main categories. First, the EPPO can be competent in respect of criminal offenses affecting the financial interest of the Union that are provided for in the PIF Directive as implemented by national law. It means that the competence of the European Public Prosecutor Office covers the criminal offenses defined in the PIF Directive. The PIF Directive contains 4 criminal offenses: EU fraud, corruption, money laundering, and misappropriation. Secondly, the EPPO is also competent for offenses regarding participation in a criminal organization if its focus is the aforementioned criminal offenses. And thirdly, the competence of the EPPO also covers any other criminal offenses that are inextricably linked to the aforementioned crimes against the financial interests of the EU. It can be seen that the EPPO regulation refers back to the PIF Directive in connection with the criminal offenses that falls in the material scope of competence of the prosecutor's office. The problem is, in connection with this, that the PIF Directive is a directive and it has to be implemented in the national laws of the member states. That means that the competence of the EPPO is bound to the national implementation of the PIF Directive. Therefore, the EPPO cannot provide a unified criminal protection, since the offenses falling in its competence can also be different based on the national implementation of the PIF directive. Secondly, some words about the structure of the EPPO. Originally, the European Commission envisaged a vertically centralized so-called office model with the European Public Prosecutor and its 4 deputies in the central level, and the European delegated prosecutors who operate in the member states. However, due to the pressure of the member states, the finally adopted EPPO regulation contains a so-called college model, which is a more decentralized structure in which the decision-making become more closer to the member states. In this way, the EPPO can take due account of each different legal systems and traditions of the member states, which could also strengthen the acceptance and the legitimacy of the EPPO. However, this system has also disadvantages. The regulation has established a 4-tier system, European Chief Prosecutor, Deputies, College and Permanent Chambers, and also the European Delegated Prosecutors, which made the division of responsibility more complex. This complicated system could hinder the quick and efficient decision-making, could lead to prolonged investigations and procedures, and ultimately it could hamper the efficiency of the organization. And finally, I would like to highlight an interesting procedural problem in connection with the EPPO. As a general rule, the EPPO regulation states that the investigations and the prosecutions shall be governed by this regulation, and national law shall be applied to the extent that the matter is not regulated by the EPPO regulation. It means that the EPPO regulation does not seek to establish a coherent and comprehensive procedural rules, but only lays down minimum rules, minimum harmonization, and in matters which are not covered by the regulation, national law shall be applied. Here at the slide you can see some examples where the national law of the member states can be applied. The problem is, in connection with this, that there are significant differences between the procedural laws of the member states. It results that the proceedings of the EPPO largely depends on the national law of the member state in which it proceeds, which can also undermine the effectiveness of the proceedings of the EPPO. Therefore, the harmonization of the national criminal procedure laws and rules of the member states would also be essential, at least as regards to the acquisition of means of proof and the rights of persons involved in the proceedings. According to my presentation, it might have been seen that I am pessimistic about the new EU legal act. However, it is not true. According to my point of view, the establishment of the EPPO can be regarded as a significant improvement in the field of the protection of the financial interests of the European Union. The problem is that the EPPO regulation contains several regulations that are opposite to the need of the unified protection of the financial interests of the European Union. The protection of the financial interests can only be effective if both substantive criminal law and criminal procedure law of the member states are homogeneous and harmonized and even unified. Until it is not achieved, the protection of the financial interests cannot be totally effective. Of course, the unification of the criminal law system of the member states is not the reality now, since the member states still do not want to give up their sovereignty in this field. However, in order to ensure an effective protection of the financial interests, the European Union has to make efforts to gradually reach this objective and has to find a proper balance between the two competitive legal interests. Thank you very much for your kind attention.
Thank you very much for extremely interesting presentation and for your time discipline. And now it's time for the last person from the last panel. And now I give the floor to Laszlo Dornfeld from University of Miskolc with the paper Cross-Border Access to Evidence in the European Union. Please welcome.
Thank you very much, and thank you for the organization of this conference. I'm very honored to be here, and I would like to share a presentation with you. Just a second. Yes. So can you see it now?
Yes, yes, we see.
Okay, thank you very much. My topic is about the cross-border access to e-evidence in the EU. I'm from the Franz Magnus Institute of Comparative Law and also a doctoral candidate of the University of Miskolc. I will talk about this rather important issue. Works. Somehow it's not going. Okay, here it is. So to start off this presentation, I first would like to talk about the birth of digitalized societies. It's often called the fourth industrial revolution, which introduced a new era of technological development to our societies. And it greatly enhanced the importance of electronic data in businesses and in government and in our daily lives. So it's rather important to ask the question, who will control the data in the future? Electronic data itself is very fragile and can be easily destroyed or manipulated, which is a rather important obstacle in case of criminal investigation, because you need to acquire the data fast and secure it so it can be used later on in the procedure. And the mutual legal assistance, which is was mainly used for cross-border evidence gathering, is rather slow. It takes usually up for 30 months to respond to these legal assistance claims. And in some countries, like in, for example, the US, the MLS system completely collapsed, which led the US government to a rather unique approach, and they allowed foreign authorities to contact their tech companies directly, which is, of course, not based on legal laws, but rather on informal cooperation between these actors. And it's not the ideal approach to tackle this problem. EU itself has its own changing cross-border policy. It tries to adopt the principle of mutual recognition in collecting evidence in cross-border cases. This principle of mutual recognition stems from the competition law, which means it's a rather alien body in the area of criminal law. And it had its fair share of problems when trying to adopt this approach. First, there were two framework decisions, one of which, the European evidence warrant, was rather unsuccessful, and it was very problematic with its scope, so it's not used anymore. And instead of it, the European investigation order was adopted in criminal matters. But this letter is primarily for physical evidence and not for digital evidence, so it doesn't really help our problem in any sense. However, there is now a new proposal which I would like to talk about in detail, and this is the e-evidence proposal of the EU, which adoption started in 2015 when the European Agenda Security was adopted, and the Council asked the Commission to create a proposal based on it for gathering cross-border e-evidence. And this proposal was finalized in 2018 when the Commission published first an assessment and later on the proposal based on this assessment. And it found the three primary channels for cross-border collection of evidence. The first of which is criminal cooperation between authorities. We can already see it's a rather slow and ineffective way to gather the evidence. The second one is a cooperation between authorities and service providers. This is the US example, which I already talked about. However, it's a non-transparent way of gathering evidence, so it's also rather out of the picture in the long term. And the first and the third of this is the direct access to electronic evidence, which the proposal tries to adopt as its primary measure. There are some relevant national court judgments regarding this question. I will not talk about this in detail. They could be presentation on their own, like for example the Yahoo Belgium case. It's a rather famous case in this topic, or the Yahoo Skype case in Belgium, which both of which ruled that American tech companies must be obliged to provide data, and e-evidence proposal has the same meaning in its words. So the evidence proposal is actually a proposal for two new laws. The first is the proposal for a regulation, and the second is a proposal for a directive. As we know, the regulation is a much stronger instrument than a directive, and it can be directly enforced. And this regulation contains the two most important parts of this proposal. The first is the European Production Order, and the second is the European Preservation Order. This is mainly focused on e-evidence, and according to the production order, some already existing evidence must be handed out by the tech company of another member state to an authority in the asking member state. And the preservation order means that they have to preserve this data and give it up later on when there is a new rule for it. These orders may only be issued for criminal proceedings, but both during pre-trial and trial phase. It can be issued by judges, courts, investigative judges, prosecutors, or any other competent authority defined by the member state itself. So it has a very wide scope of authorities that can issue these orders. It affects all companies providing services in Europe, regardless of their location. So American tech companies no longer can have free reign, given that they are America, and they cite this as get out this problem card, which means that now every tech company should provide the requested information to the authorities of the member states. The other member state should only be notified if the request is not complied with, so it can be enforced. Also in the directive, the most important part is that tech companies which operate outside of Europe must nominate a representative responsible for enforcement and compliance with these orders, and they of course have to be responsible for enforcement in their own person. So they would go to jail if these orders are not enforced, which is a rather harsh term. Of course, for such an important proposal, there were many debates, and there are still many debates regarding this on many fields, because it's a rather complex approach. And of course, the many different actors and institutions of the EU could not really agree on a unified approach. And of course, they have their priorities set different. Member states mostly debate that their authorities should be notified at the same time as providers. As we can see in the original proposal, they are notified only when the enforcement of the order is in question. And according to their opinion, the authority of the notified member state could initiate a consultation with the issuing authority, or have the power to review the legality of the decision or to refuse to enforce it. So it gives a rather large sway of things to the member states in their own opinion. The scope of the proposal is too wide, some argue, while others say that it's too narrow, so it's hard to be the judge here. For the too wide argument, they say that even very small service providers are also forced to comply, and of course they do not have the required infrastructure to do so. And another problem which many find lacking is that the real-time data interception is not part of the proposal. So if you are interested in information that may be created in the future, like for example, communication between criminals regarding the cyber attack, which will happen in the future, we can't use this order to produce this as an evidence, because it can only be used for evidence that already exists. And they argue that authorities should receive real-time access to data instead of a copy, which is in the current proposal. And also another problem is that data retention was found incompatible with EU law many years ago, and since then no new regulation was adopted in the field, which means that ISPs delete their data caches regularly, and they do not keep this data, which means that, for example, a year later, you could issue this order but not get any information in return because it was already deleted from the servers. There are also fundamental right aspects. Because of the time, I will be very short on this, but you should know that it's a rather important aspect. For example, subscriber data in itself, it's not dangerous for the person's fundamental rights, but if they are collected automatized, it can be already be above a certain level of infringement of fundamental rights. So concluding my presentation about this very interesting topic, first I must say that this proposal, of course, was not adopted until 2018 session of the European Parliament. And since then, because of the COVID crisis and other problems, the dialogue on this question was rather slow and ineffective. But the proposal itself has clear benefits. For example, it creates a clear legal situation and a uniform legal procedure at an EU level for e-evidence, which is a rather good approach, you know, opposing to what we have now, which is fragmentized and barely usable legal landscape. However, it is important to respect fundamental rights, and the proposal should be balanced out regarding this topic. And of course, it's now rests on the European Commission to find a common ground and between different concepts and try to compromise in this question, because I think if it's adopted, it can be a big step ahead for e-evidence gathering in cross-border cases, which is a big problem right now. So I would like to thank you for your attention. That's all.
Thank you very much for your speech, and I would like to thank everyone who participated in this panel, and we have a short break, and we start the next panel at 12 AM. Thank you.